Good morning, everyone. My name is Cassandra Cison, and today I'll be speaking about International Prosecution of Sexual and Gender-Based Violence, or SGBV, and new conceptualizations of rape as an instrument of war, as applied to the ICC case of Jean-Pierre Bemba Gombo. In particular, I offer a theory of rape as de facto torture and slavery. I'll be going into further detail later, but essentially what I mean by that is, in the context of times of conflict and where acts of severe sexual violence is perpetrated en masse against civilian populations, the conceptualization of rape as being tantamount to torture or slavery by their very definitions can offer a means to address the issue of continued SGBV impunity that we see out of the ICC. That being said, I've also added this caution sign as a trigger warning throughout my presentation, as some of the details in the cases I'll be discussing can be quite graphic and cover potentially uncomfortable topics, as you can imagine. So first, I'll be discussing the Bemba case, his role in the context of the conflict, the ICC's landmark 2016 conviction, and subsequent landmark acquittal in 2018. Then I'll move on to discuss in more detail SGBV crimes as de facto torture and slavery, their precedents in various ad hoc tribunals, and their applications to both Bemba and the future of prosecutions going forward. Bemba's role in the conflict leading to his charges begins in October of 2001, when the government of the Central African Republic, or CAR, dismissed General Francois Bozizé from his position as the nation's military chief of staff. Subsequently, a substantial number of soldiers from various FACA troops, or the Central African Armed Forces, followed and deserted their posts in support of Bozizé, initiating an armed rebellion against the CAR government, which at the time was under the administration of President Félix Patassé. In response to the insurrection, FACA soldiers and various other militias in support of Patassé retaliated with armed force, including a bombing campaign that began in October of 2002. During the emergence of this rebellion, Bemba was the president of the MLC, or the Mouvement de Libération, a militant political organization in the neighboring DRC, the Democratic Republic of Congo, that he'd established in 1999. Bemba also served as commander-in-chief of its military branch, or the ALC, and in that capacity, he was responsible for determining the execution of the organization's military operations. At the request of President Patassé for military aid in the defense against the Bozizé insurgents, Bemba mobilized MLC troops to cross into the CAR in late October 2002, which lasted for 5 months until February of 2003. Despite Bemba himself actually remaining in northern DRC, he was still able to communicate with and retain control over his troops in the CAR, which was a critical factor in the ICC's determination of Bemba as a remote commander. Over the course of this campaign to suppress the conflict, MLC forces were alleged to have perpetrated extensive criminal acts throughout that 5-month period, committing several atrocities against the civilian population in the CAR, including murder, rape, and pillaging. What makes this case unique in several ways is not only that Bemba was acquitted, but that it was the first ICC case to include both charges and a conviction for crimes of sexual violence against both men and women, and was also the first ICC case to tackle Article 28 command responsibility doctrine. So here we have a timeline of events. We know that the story begins in 2002, and in 2004, the CAR, a party to the Rome Statute since 2001, formally requested the ICC to investigate the crimes committed by the MLC. In 2008, the ICC pretrial chamber issued an arrest warrant for Bemba, and he was later apprehended in the vicinity of Brussels by Belgian law enforcement. Then we have the 2016 conviction and 2018 acquittal. Here are some pictures of Francois Bozizé and President Patassé. So the Bemba trial was first at the ICC to focus on rape as a weapon of war, and it was widely hailed as a landmark case for the prosecution of SGBV crimes that continue to be committed in conflicts around the world. While SV crimes had been prosecuted in other ICC trials, none had actually resulted in a conviction. The then ICC prosecutor Ocampo, highlighted the hundreds of victims reporting rape and other abuses. He also explained that this was the first time that the ICC had opened an investigation where the allegations of sexual crimes far outweighed alleged killings. One report suggests that of around 1,000 civilian victims, 700 were survivors of rape. The trial also featured the highest number of witnesses testifying to the commission of sexual violence. So moving on to the basis of the conviction, the trial chamber convicted Bemba of 2 counts of murder, 2 counts of rape, and 1 count of pillaging, sentencing him to a term of 18 years in prison. While the chamber did not find that Bemba had actually committed any of these crimes personally, they held him liable under the doctrine of command responsibility, which is derived from Article 28 of the Rome Statute, which is here on the right. They interpreted command responsibility to require that the accused have 1, effective command or control over the troops that committed the crimes, and 2, fail to take all necessary and reasonable measures to prevent the crimes from occurring. Taking guidance from the jurisprudence of ad hoc tribunals, they defined necessary measures as those appropriate for the commander to discharge his obligation, and reasonable measures as those reasonably falling within their material power. The chamber found that Bemba had taken some measures to prevent crimes from occurring, but that these measures were, I quote, grossly inadequate and were not taken with the genuine purpose of prevention, but rather to positively influence the public appearance of the MLC. They reasoned that even if the commander had no power over the actions of his troops, or only had inadequate measures, he'd still be obligated to submit the matter to appropriate authorities. With an unprecedented prison term of 18 years, Bemba had received the harshest sentence handed down by the ICC thus far. Nevertheless, the prosecution contended that the severity of the offenses justified a 25-year imprisonment. So both the prosecution and defense challenged the sentencing. Bemba appealed both his war crimes and crimes against humanity convictions on the grounds that the trial chamber should have found that he had, in fact, taken all reasonable and necessary measures. But in June of 2018, the Bemba judgment was reversed by a split ICC appeals chamber. The appeals chamber found serious errors in the trial chamber's assessment that Bemba did not take necessary measures of prevention, and that they failed to fully appreciate the limitations Bemba faced as a remote commander. The majority also altered the standard for command responsibility. Under that doctrine, a commander has a duty to take all necessary and reasonable measures. But the majority found that the scope of commander's duty would vary in relation to his actual ability to do so. They stated that it's not necessary for commanders to take each and every possible measure, and found that commanders must often engage in a cost-benefit analysis to determine what measures to take. They rejected the trial chamber's consideration of hypothetical measures that Bemba could have taken, and instead required an evaluation of whether a commander took specific and concrete measures available to him or her and which a reasonably diligent commander would have taken. Moreover, the appeals chamber determined that Bemba was substantially limited in his capacity as a remote commander to take measures and maintain command over his MLC troops while located in the DRC. So while Bemba's acquittal obviously had a devastating impact on the ICC and undermined what many had lauded as a sign of progress, the court's decision still affirmed the growing recognition of rape as a weapon of war and its profound effect on victims it's used against. Despite the impunity that was doled out by the appeals chamber, that rested not upon the court's neglect of sexual and gender-based violence crimes, but on the nuance of Article 28 command responsibility doctrine. Although the appeals chamber ultimately acquitted Bemba, the majority ruling in the original verdict still suggests initiative from the ICC in its evaluation of the elements of rape. They broadened the definition of invasion to be gender neutral and specified that the invasion necessary for rape was intended to be inclusive of all genders. They also removed the lack of explicit consent as an element of rape and determined that it's not essential to show a victim's lack of consent if the prosecution can establish the components related to the use of force, coercion, or taking advantage of coercive conditions. Moving forward to discuss new understandings of rape, I've provided some statistics of SGBV crimes during times of conflict in Rwanda, Bosnia, Yugoslavia, Sierra Leone, and the DRC. A comprehensive 2011 study places the figure between 1.69 and 1.8 million women in the DRC of having been raped in their lifetimes. I'd also like to note that this figure is exclusive to women and is also likely conservative, as many victims of sexual violence don't come forward. And underreporting by both men and women is one of the main factors contributing to the perpetuation of SGBV impunity. Similar to the prevalence of SV against women and girls, sexual violence against men and boys has a long history and a far greater number of occurrences than previously assumed. Contrary to traditional notions of SV against men, recent studies show a more intricate reality, challenging the belief that victims of sexual violence during conflict are exclusively women and the offenders exclusively men. One example is that of Pauline Nyiramashuko, convicted in the ICTR for inciting soldiers to commit acts of sexual violence during the Rwandan genocide in 1994, and Biljana Plavsik in the ICTY, who pled guilty to persecution as a crime against humanity, including sexual assaults and rapes during a long campaign conducted with particular brutality and cruelty, including torture and sexual violence. The ICC statutes elements of rape as a crime against humanity, on the top left, require 1, invasion resulting in penetration, however slight, 2, committed by force or by threat of force or coercion, or by taking advantage of a coercive environment, or committed against a person incapable of giving genuine consent. 3, was committed as part of a widespread or systematic attack against the civilian population. And 4, that the perpetrator knew that this conduct was part of or intended to be part of a widespread or systematic attack. The only difference in the elements of rape as a war crime are that the third and fourth elements require the existence of an armed conflict. Other tribunals, such as the ICTY or the ICTR's, precedent and prosecution of rape is much further along than the ICC's. The ICTY was the first to convict rape as a crime against humanity, and the ICTR was the first to convict rape as a crime of genocide in 1998 in Ahiasu. Going forward, under new conceptualizations of rape as de facto torture or slavery, the future of the ICC and its prosecutions against SGBV may prove to look very different. Beginning with rape as de facto torture, colloquially, we conceptualize the thought of torture as being distinct from that of rape, and we can visualize equally graphic and cruel, but nonetheless entirely different acts of pain. Abu Ghraib and Guantanamo immediately come to mind as examples of what torture traditionally looks like. But what typically does not come to mind is whether victims of torture had ever consented to the human rights violations and war crimes committed against them, or if there was ever an element of consensual capacity or acquiescence they can provide to effectively nullify the torture they endured and provide impunity to the offenders. Torture at its most base are acts of degradation, pain, and punishment. More appropriately, the mental suffering suffices to establish the crime of torture. The Rome Statute's elements of torture concentrate upon intentional infliction of pain or suffering, whether that be emotional or physical, and the only additional requirement is that the victim is in the custody or control of the perpetrator. The Rome Statute's potential interpretation essentially deletes any element of official capacity and underlying purposes for the commission of the Torture Act. The conceptualization of rape as being classified as torture begins to make more categorical sense, particularly when confronted with acts very heinous, and the coherency of these subsumed categorizations or labels begins to grow almost obvious. These next cases both illustrate my previous statement and demonstrate rape as torture's grounds in other tribunals. In the case of Prosecutor V. Delalic coming out of Yugoslavia, male and female Serbian victims detained in a detention facility where the camp's deputy commander committed sexual violence with the purpose of inducing terror. Male detainees were subjected to sexual violence, such as when a father and son were forced to endure a sexual assault and commit fellatio upon each other. Men also endured sexual torture by the application of live wires tightly wound around their genitals. The trial chamber there concluded that these acts were considered as torture, as classified as a war crime under Article 3 of the Yugoslav statute, and that they also amounted to cruel and inhumane treatment. In the case of Prosecutor V. Tadic, Bosnian Muslim male prisoners were forced to lick each other's buttocks, commit fellatio, and sexually mutilate each other. The trial chamber held that these acts of sexual violence could amount to torture under Article 3, and the appeals chamber also found Tadic to be criminally liable for sexual abuse as inhumane treatment under Article 2. Another possible reimagining of sexual and gender-based violence is that of rape as de facto slavery. Rooted in Article 7 as a crime against humanity, the elements of enslavement include the exercise of the right of ownership and the deprivation of liberty. Its definition is explicit in its basis on ownership and control. And what's undeniably present in all instances of sexual violence is the deprivation of victims' autonomy, bodily rights, and personal dignity. Rape exists sub silentio as a form of criminal conduct that underpins other international crimes, such as trafficking, slavery, the slave trade, or slavery-like practices. In the case of Habre, out of the Extraordinary African Chambers, or EAC, victims testified that Habre and his soldiers detained them in secret prisons as sex slaves, perpetrating acts of violence including rape, genital injury, forced nudity, electric shocks on sexual organs, and forced contraception. In 2016, the EAC found Habre guilty of committing rape and sexual slavery as crimes against humanity as well as torture, and held Habre responsible for the crimes committed by both his subordinates and himself. The trial chamber concluded that enslavement could comprise acts of a sexual nature, and that sexual control can be a means through which to carry out enslavement. The court further noted that the exercise of sexual control can be considered part of the customary law of enslavement. Under international law, slavery, enslavement, and the slave trade is recognized as an absolute and non-negotiable principle, with its basis rooted deeply in historical conventions and conflicts. In the Habre majority's analysis, the court referenced multiple legislative instruments and historical foundations to support the conclusion that the safeguards of jus cogens and customary international law condemn sexual slavery as a crime against humanity and a war crime. Accordingly, the court concluded that international customary law recognizes sexual slavery as a component of enslavement's actus reus. Finally, this brings us to the potential impact of rape as de facto torture or slavery. While I'm hesitant to invalidate the clear distinction between the invasion of autonomy that's present in rape versus that in traditional notions of torture, beyond de jure categorization, its conceptualization provides an at least partial countermeasure to the previously mentioned factor of underreporting that contributes to continued impunity, and male victims' hesitance to do so in light of the pervasive cultural stigmatizations associated with rape. Even the linguistic distinction of a single word may have the effect of eliminating much of what prevents male victims from reporting. There's something to be said about the likeliness of a male survivor to speak out against his abusers as a victim of torture, as opposed to a victim of rape. Furthermore, the categorical classification of rape as slavery may provide an effective tool to address crimes of sexual violence, as the historically and traditionally established erga omnes crime of slavery may offer the legal basis power to effectively pull sexual violence under its metaphorical definitive wing, sexual slavery not as a separate crime, but of sexual violence as slavery itself. Often persisting long past the ink has dried on peace treaties and prosecutions of war crimes on an international level, Crimes of sexual violence against both genders and against all ages remain at once amongst war's greatest atrocities and loudest omissions. With consideration of its grounds already present in the jurisprudence of other ad hoc tribunals, a strong case for grounds in customary law, and a solid textual basis to be subsumed in relevant articles of the Rome Statute, new conceptions and understandings of rape as de facto torture and de facto slavery can offer a powerful means to address sexual and gender-based violence, curtailing impunity for offenders and granting justice to the victims of rape as a weapon of war. Thank you.